all right, to attack a company if you can just attack a cloud provider and get everything. So it becomes an increased threat because there's more of it, and because people are leaping without investigating. Plus, cloud providers sort of popping up, and everybody wants to do cloud, right? We do cloud. It's like, it's not even cloud, right? It's like iTunes or something, and you don't know who's running them, and it's not your old standard. We have a business interest in keeping this going. It may be these startup companies, and you can't tell how big they are, right? Because it's just available, it's scalable, until it isn't. Right, and a lot of the providers are either new or doing new things that are sort of untested, and they're trying to do them very quickly.
And isn't that true for most IT things, where the legal thing trails the actual technology?
Right, although some of this trails by a lot. I mean, the Stored Communications Act, basically, it talks about data as if everything was frozen in the 80s, right? Only data in transit, only data at rest. And so these things, it's not like, oh, we're just a little bit ahead, right? They don't even bother. And some things just will never catch up, right? This problem with seizure of data. What are you gonna do, right? Microsoft proposed recently, about 2 weeks ago, I want to say, a new law just to cover cloud computing. So you may see these things as lawmakers run for re-election, but it's not just that the laws are trailing; it's that the system just isn't designed for this, and people don't tend to think about it, and when they do, they'd rather not.
Do you know of any notable cases that have been actually cloud computing cases that have actually been murdered?
Well,
if you could paraphrase the question too, again, for the internet.
Sure. Sorry. Do I know of any cloud computing cases? You're not going to see really. I mean, unless there's something involving a cloud provider directly. Cloud computing cases per se, you're going to see e-discovery cases where the stuff is stored in the cloud, and it'll be hard to tell, what happened. Now there have been, in discovery, it's not easy. Oh, yeah, you provide this and we provide this and we're all happy. There are big fights, and there are sometimes orders, or at least requests for orders that companies turn over a hard drive because they haven't turned over the data they're supposed to. When you get a subpoena, what you do is you search through. Your lawyers search through, really. And you pay them a lot of money to read everything, make sure it's something you can disclose, and then they send it out. But if you screw around, judge may order you to give up your hard drive or an image or something like that.
You talked about different privacy laws and international privacy laws and state privacy laws. Is there a resource that provides a good mapping for companies for guidance, especially on the international side?
There are, so the question was, is there a good way to find out what all the different laws are? Ask a lawyer. There are some on the web. You can find some tables of state laws, but they tend not to be updated. So they're a little bit behind. They also don't tell you exactly what you need. They'll sometimes point you to the statute, then you got to figure out what you do if there's a breach. And so depending on what you're doing, it's a research project. You have to figure out which laws are going to apply to you and how and what you have to do. So I don't know of any, books you can sort of buy or websites you can go to. Yep.
In regards to the earlier we were talking from privileged conversations between attorney and client, and the requirement for a reasonable amount of protection on the end of the client. Do you know of any precedents one way or the other regarding usage of a cloud information service like Gmail? And has that been either shown or not shown to be a reasonable method of protection to maintain client attorney privilege?
So the question is about attorney-client privilege and whether there are cases about whether using the cloud or Gmail or anything like that remains protected. There are cases about Gmail. They tend, and other email providers like that, they tend to talk about whether your employer can look at your email that you use from work. So they don't really relate directly to the cloud, even though it's not at all private, right? It's like, it's a postcard written in pencil, but for some reason it's thought of as private. But for cloud providers, it's very new, and it'll really be fact dependent, right? What did they do? Maybe they did nothing. There was sort of related, it's the same idea. There was a case in Iraq when the Iraqi Provisional Authority was in charge, this sort of pseudo-governmental thing, and there was a company called Custer Battles, which is a great name for a company, especially because it was started by two guys, one named Custer and one named Battles. And they were supposed to provide security. One of the things that involved was bomb-sniffing dogs in Iraq. And they just provided regular dogs. They just sit there, and they wouldn't sniff anything. And that sort of thing, you know, the U.S. government went after them and lost because they weren't actually providing service to the U.S. government. But it went pretty high to the appellate court, and that was if it were that sort of thing where you just had regular dogs, right? That seems objectively unreasonable. After that, it's a gray area. You know, if you leave your notes sitting on a table at Starbucks, not reasonable. If you put them behind a crappy lock in your office, probably reasonable. It's hard to know. Other questions? Yep.
Actually, the issue of emails in a company environment, who owns the client corporate email? But is it the owner of the company?
In this country, it
Implications?
tends to be the company.
So even if you get a private email,
I'm sorry?
even if you get a private email to your corporate email account, the owner of the
There's-
firm can basically say, this is my
Well,
property.
it depends on what their policy is. It's less a question of property because it's data and copied, and more a question of who has a right to look at it.
That's usually an
Um,
agreement that you sign at employment.
Oh, sorry, the question was who owns email, by the way, for the kids at home. And there have been recent cases about that, both with the government and with private companies. And it tends to be what the policy is and do they actually follow through on the policy. You.
What if it's private email through Internet Explorer using webmail, and it's their personal email, like Yahoo or whatever, and they're using it at work on the work's access? Whose property is it?
So the question was whose property, although I think, again, that's not exactly the right question, is email, personal email like Gmail that you access over the web at work. I mean, you own it, but the question is who gets to look at it. Part of it is a question of what the employer's policy is, and part of it isn't. And there are cases being litigated now. These usually tend to involve employee cases, right, where there's employees suing the employer for discrimination or something like that. They tend to be private, but again, it depends. If you're doing it unencrypted and your company says that they watch all traffic, you know, then it seems like they have a right to look at it, but we don't know.
So you kind of talked about, like, you know, the company set the rules, they set the terms and conditions, the cloud provider says, you know, you have these rights, these are revoked, whatever. So what? I mean, like, what's driving them other than corporate reputation to improve their handling and you know, privacy systems, you know, the control of the data, the safety of the data? Is there enough penalties out there from a federal standpoint for these type of breaches to even make them better at what they do, to think about the client's privileges and rights, and not what they do today?
So the question is what's going to drive these private companies to do better? Are there federal or state laws that will punish them? Some of it will be the marketplace, right? They'll have to compete. Some will be they'll get sued for doing really stupid things. That will be fun to watch, unless it's your data. And then you're gonna, just like everything, you're gonna have, think of Toyota, right? Toyota with this big company, it's got this great name, cars that are known as reliable, and they don't stop all of a sudden. And now GM is running commercials saying, our trucks stop. So, I mean, there are gonna be mistakes, but I think it's gonna get better. As I said, some things you can't fix, but I think some of these are going to get better. The agreements will get better, although not for consumer things. I think Google Docs will, for as long as we care about, still not warrant anything the way they do with Gmail and everything else. But for businesses,